If your insurance claim has been denied, then this is for you. Welcome to the Policyholder Podcast. My name is Danielle Snell and I'm the co-founder and managing partner of Elit Lawyers. Each week, we meet with legal experts and industry insiders to delve into real-life cases of insurance denials, discuss common trends and patterns, and talk about strategies to navigate insurance issues. Whether you're a policyholder seeking to challenge an insurance declinature or a legal professional seeking to navigate the complexities of insurance law, this podcast will provide practical steps to help you take that next step. The Policyholder Podcast starts now. Today we're honoured to have Chris Archibald King's Counsel on the show. Chris is a distinguished KC with extensive experience in commercial law, including class actions and insurance. He has served as a reporter for both the Victorian Reports and Australian Law Reports and has published articles, including on the terms of good faith in contracts. We've seen Chris firsthand in court delivering cases and witnessed his impressive advocacy skills, and we're absolutely delighted to have him here today. Welcome, Chris, to our show.
Welcome. Thank you. I'm delighted to be here too.
Chris, to start off with, can you explain how you think insurance contracts differ from other types of contracts and what this might mean for a policyholder?
Well, I suppose every contract, being the agreement between two or more parties to do something, has as its core the thing that the party's going to do, but then always on the back of all of that is the risk allocation, because always things can go wrong. And so agreements tend to provide, if something's being sold, then what happens if it gets damaged in transport, or what if the payment goes wrong? So there's always a risk allocation. But what's distinctive about insurance is that it's really only the risk allocation which is at the heart of the contract. And so that tends to make the agreement between the parties, the policy, a very subtle and arrayed mix of the risks that are being balanced and shared. So it's often a rather nuanced jigsaw puzzle of provisions which are allocating the risk one way or the other. Because, of course, the risk might never happen. And so in the ideal world for a policyholder, things don't go wrong and you never need to call on the policy.
Of course. The common issues that we see when they first come to us are, would you say, Rob, that they see there's been quite a protracted history. There's been a delay associated with when they first lodge the claim. There's a bit of frustration around that, isn't there, Rob?
Certainly.
And then they also are they can be unclear as to what further documents they need to provide and what the underlying reason is as to why the insurance cover has been declined. And often that's intricacies and the detailed analysis that goes into what the true reasons are.
Well, it's interesting. And in that context, Chris, what are the sort of common issues and themes that you're seeing when you're representing clients in respect of insurance contracts and indemnity under policies?
Well, often it's the case for a policyholder that takes out insurance for the very circumstance they hope will never happen, and then something like it does happen. And there can be an expectation that, of course, the policy will respond, and complete surprise if for some reason the insurer takes a different position. Now, sometimes the difference in position can be a dispute about whether something did take place and the facts and how things transpired. Sometimes it's a dispute about whether the wording of the policy responds and whether the insurer thinks it's taken on the risk of the event that's happened. So I suppose from my perspective, sometimes the bridge to cross is to get over the surprise of a declinature or a denial, and then to look more broadly at the policy to see how it stitches together. Because sometimes leaping straight to page 32 and the subclause that seems to say exactly what you wanted to say rubs up against what the insurer overall reads the policy to provide for.
It's an interesting concept for policyholders when they deal with it. One of the issues that we find is this: the product disclosure statement can sometimes be 132 pages long with a number of different sections, and it's very confusing for insureds to navigate, in particular the interpretation of certain clauses in the policy. And I gather that that's an issue that arises a lot in insurance.
Well, it is, because, as I was saying, I suppose at the start, the interlocking of different risk calibration from the insurer's perspective when they draw the policy means that on the one hand, things are given, on the other hand, things are whittled away and balanced differently. So you get a coverage indemnity provision that then has some provisos and qualifications, and then you turn 30 pages later and there's an exclusion and an extension right at the back with a schedule. So all the pieces can't really be seen in isolation, and it needs them all to be stitched together. So that's often the challenge and the confusion for a policyholder when those pieces haven't been put together for them.
In terms of when you are reviewing an insurance policy and making sense of it all when the case first does present to you, is there any focus that you tend to have when if you're acting for a policyholder versus an insurer, or is it they're largely the same sorts of considerations?
Well, I suppose there are two parts to it. I mean, the first is that they're the same in the sense that there is
Same
one policy, and
yes.
if the dispute has to run all the way, there'll be one court that determines one answer. And so the exercise is driven from the perspective of trying to find what is going to be the most likely or compelling, most cogent argument that's ultimately going to win. But having said that, the initial exercise is to try and find what is the best cogent argument that will suit the client's interests and outcome. So it's when I was describing before the interlocking provisions or the different layers of risk, the way I try and look for it is to try and pull them all together in a way that has a narrative or a thread or a story that underlies what otherwise might be the opportunistic or the focus on a particular clause and the meaning of a particular word and driving that outcome. But it so often needs to be supported by something that sits underneath it to make all the pieces hang together, so that the court is able to sign up to the specific outcome that might be driven by a particular wording or a particular clause.
It's interesting, Chris. In recent times, anecdotally, it's being said that it's a lot tougher for policyholders out there because insurers are tending to deny indemnity in circumstances. Is that, generally speaking, is that what you're finding as anecdotally?
I perhaps don't have a very good insight on a lot of data points across an industry. What I have been seeing through my own practice and more generally in the press is the keenness of the regulator to make sure that whether they're being denied or agreed, or that the process is much more transparent and fair, both as to the timeliness and the transparency. I think in the last week or so, the Australian Securities Investments Commission has published a report, and it's part of its recent monitoring program towards that. So I haven't seen necessarily a wave one way or the other. They tend to be case specific, of course, but there's certainly a swell to ensure that the industry is processing and responding in a way which is procedurally fair.
Because one of the frustrations we see at the front end of these things is that specifically in the insurance policy itself, there's no provision in terms of how long they must take. It's the overlaying good faith obligations. It's the overlaying code of conduct that seems to provide and that's the frustration with a lot of people about timing and what the insurers must consider and how often, how long they have to determine their attitude on liability in relation to a claim.
And and I'll add to that. There's often a number of document requests that any insurer will make to a policyholder, which is quite understanding, and there's duty of disclosure and so forth. But what policyholders are unaware of, aren't they, is that under the Insurance Code of Practice, they can also request documents from the insurer, including transcripts of interviews and investigation materials and the like. And so that also assists when we're analysing the status, because we need to understand, don't we, Chris, why an insurer has declined a claim in as much detail as possible.
And policyholders shouldn't feel backwards in coming forward to assert their entitlements to obtain a proper explanation or the proper justification, and indeed with the timeliness too. So if for some reason there's been radio silence from the insurer for unexplained reasons, then the policyholders should feel capable of being on the front foot and demanding an explanation at the very least, even if the answer isn't yet.
And it's interesting that very concept is enshrined in the Insurance Code of Practice, that they've got an obligation to determine the question of liability within 30 days, but in certain circumstances they may not be able to. In those circumstances, the insurer is required to notify the insured and indicate what further documents are required, what the likely timeline is. And we're seeing that as a matter of frustration with policyholders in terms of understanding that process, because they seem to a never-ending inquiry before the issue of liability is determined.
Yes, that can be very frustrating for policyholders.
And there's also that provision in the Insurance Contracts Act, Section 42.
42 that require a policyholder can in fact write to an insurer and ask the insurer if they admit liability under the terms of the contract. Yes,
and that can stimulate a bit of spotlight focus from the insurer.
Just on this subject, let's cover the duty of utmost good faith, because it threads in nicely to what we're talking about, which is in Section 13 of the Insurance Contracts Act. It obviously governs the obligations of each party during the insurance claim. Chris, how do you interpret the duty of utmost good faith? Just practically, I mean, we hear a lot about what the name of what the duty, good faith is the terms used a lot, but practically speaking, what do you think it means, and how have you seen it play out in terms of actually making a difference?
Well, it manifests in two particular ways. We know from the High Court's authority that on the one hand, it introduces implied duties to do things. So classically, a policyholder needs to disclose to the insurer beforehand relevant circumstances before they take out the policy. But it also operates as a throttle or a qualification on the way in which parties can exercise their rights once they've entered into the contract. And so it is well applicable, for example, to an insurer and the way in which they handle a claim and the timeliness and the clarity and the responsiveness and the provision of rights to the policyholder during the processing of a claim. And so at the moment, that's one aspect that I know the regulator has been using as an angle of its enforcement tools to bring about the processing of claims and the handling within the industry.
So for people listening in that want to get a bit better grasp of what this duty is, could you provide with the regulators, what are they really pinpointing as what would constitute a breach of the duty of utmost good faith? Is it significant delays? And
delays is one factor, and so there's a proceeding in the courts at the moment where storm damage was suffered by a home owner, and it took a long time for any emergency repairs to be conducted, even though that was one of the rights under the terms of the policy. And then it took a long time to engage expert assessment of the structure of the building. All the while, the building was damaged and the home is suffering leakage into the bedrooms and so on and so forth. So the delays is one factor, but sometimes it's the delays in taking subsidiary steps under the policy or the claims handling, not just ultimately the delay in giving a yay or a nay answer to the ultimate claim.
And that is a good segue into, in insurance cases, it's not just about, is it, Chris, whether or not the policy will respond. It's about what indemnity will extend, so the quantification of loss under the policy. It can often be a complex assessment. Do you have any high-level observations about quantification, basis of settlement, that sort of calculation of loss when you're dealing with insurance policy assessments?
Well, it can vary, understandably enough, with the terms of the policy, and different kinds of policies provide for different kinds of loss and how they're to be assessed. So a property damage claim, a storm damage to a home, will be much more driven by the value or the cost of the works that are going to be undertaken, and that may or may not be a straightforward exercise if, for example, parts of the premises have been poorly maintained or not designed properly in the first place. And so there'll be perhaps a difficult question about which bit of the damage is attributable to the storm and which bit is attributable to pre-existing problems. Business interruption insurance is a different kettle of fish, where the losses are economic rather than physical or tangible, and often hypothetical, because where the business has been interrupted in its operations, the loss value is what would have happened, or the difference between what would have happened, and so there becomes a hypothetical scenario that needs to be portrayed and persuasively demonstrated. So that's a different.
It's interesting, Chris. Under those policies, the ones you talk about, that in terms of establishing the economic loss, that can often involve engagement of a forensic accountant. The other thing that policyholders often find is this: there are provisions in policies for claims preparation costs, and there's a bit of law on that. And if you could, have you come across that? And what's the general rule of thumb in relation to what's claims preparation costs and what's not?
Well, there's sometimes, yes, a distinction between whether what's being done is really just the internal preparations of the policyholder themselves, or indeed gearing up for legal proceedings, or whether what's being marshalled is really the information to be put on the platter of the insurer ready for responding only to the claim. And so often the claims preparation costs are really only a slender subset of the real world expenses incurred by the policyholder.
That's an interesting segue into a case.
We wanted to speak to you about a case that we ran with you last year, Chris. We acted on behalf of theatre operators, the Mariner Group, and in particular, they own a number of theatres, including the much beloved Princess Theatre in Melbourne. And they brought, didn't they, a business interruption claim against Ansvar Insurance relating to losses that they'd suffered as a result of the COVID pandemic.
Yes.
And ultimately the case ran to trial, and the policyholders were successful in that the court ordered damages pursuant to 2 separate periods of insurance. At a high level, what do you think ultimately contributed or led to the success for the policyholders in that case?
Well,
Chris?
the case was pursued by the Mariner Group in the background of other COVID business interruption cases having been run. Several test cases had been run in the years previously.
Including the High Court case at the very beginning.
Indeed. Yeah. And notably, the insurers had won nearly everything all the way along, or been able to cut things off at the knees to deny policyholders the coverage for business interruption, which had been so widely suffered. The linchpin for many of those cases was that the coverage for pandemic loss that might have responded was not available where the directions from the government had been more broadly responsive to public health instead of being targeted for a particular premises. And so many of the lockdown rules were for the broader public health, and that's why the circumstances of lockdowns generally didn't engage with individual policyholders' closures. It was different for the Mariner Group, perhaps fortunately. They had a policy with different terms, which enabled them to obtain coverage where the closures followed rather than were directly connected to the government directions. And also the terms of the Mariner Group's policy enabled them to take it up where they followed advice from the government rather than being compelled by government instrument. And so those two differences in their policy were aspects which were enabled them to succeed.
And it highlights that thing that we have to talk about all the time, that is the interpretation of the terms of the policy.
What stood out to me about the Mariner case is ultimately what it really boiled down to at the end of the case and reflected in that judgment was that the sublimit was found to apply for each of the premises, and that was just not a position that the insurers accepted from the very beginning, in the sense that it was their position that there was one sublimit and it was in the aggregate and it would apply across all premises and over one policy period. And ultimately the judge found that that was not so and that it ought to apply across each of the premises and the two policy periods. And so what really stood out to me really in any insurance dispute, and usually obviously the cases that will flow through to the courts will be of a high enough quantum, in the sense that there needs to be the proportionality as to legal costs associated with all of that.
Yes.
But ultimately there's lots of different scenarios in insurance cases, aren't there, Chris, in that it could play out one of a number of ways. When you're sort of, by the time a case gets to you, it'd be close to trial point or, in preparation mode. Are you there dissecting the different ways in which it could flow out and the different scenarios?
Yes, of course. I mean, there's always a part of running a dispute through the court process is not yet knowing everything that's going to happen during the course of the hearing.
Yeah.
Yes.
And it involves needing to anticipate the possibilities of what the opponent, the other side, may do if they change tack or change focus or so forth. And indeed, the new interested person in the room is the judge who may have new and different questions. So that's being able to work with that is absolutely part of it. And so the other thing that flows out of that and flows out of team members joining the process of bringing the dispute is that issues change and refine. What might have been the biggest and most obvious sticking point when the claim is first made to the insurer becomes refined and shifted, and there are new angles and new light shed on things. And so that can need not just new ideas or new arguments and new responses, but sometimes new expertise or new skills to bring into all of that.
With your experience at the bar, Chris, are there any key lessons or learnings that you could share with the people listening to this podcast?
Well, from a policyholder's point of view, I suppose the most important time is when you take out the policy and ensuring that the policy is suitable as best you can tell for the needs is fundamental. And so whether it's ensuring that you have the right advice through a broker or through your own assessment of what product you're obtaining, that obviously plays the basic role in whether or not it will ultimately do what's needed. So is it a policy that describes the perils or dangers or trigger points in the right way to suit your circumstances, suit your business? And does the machinery for what is required to be indemnified then fit well? So if it's a business interruption issue, does the calculation of the loss actually line up properly with your business or your circumstances, or is it just a way of doing things but not the most suitable or the most advantageous for dealing with your business?
And that's something your broker can give your advice on, can't they? Because it ultimately comes down to whether or not there are gaps in your risk. You need to analyse your risk.
And brokers can also have experience and understanding of what the market is offering too, so that it's not just a matter of swallowing what one particular insurer proposes from their point of view they would like to offer, but whether or not There are other insurers out there that may offer a different product or different terms, which may or may not come with price consequences. But at least an informed evaluation of what product's being obtained is better, because not all policies are the same.
So policyholders, I think a lot of policyholders make the mistake of just looking at the schedule of insurance, which is usually a 2 or 3 page document, and whereas the devil's in the detail in the PDS that can extend for 20 to 130 pages, and it's important to get an understanding of the exclusions that apply, the limits of indemnity, and to the extent that there's any query, they should, if they have a broker, raise it with their broker, but satisfy themselves that it's fit for purpose for their business.
That's right.
Yeah.
Chris, we might move to what we call the rapid fire round now. Just 3 sort of short, sharp questions. And the first one is, one thing you think people always get wrong about insurance, or can sometimes get wrong about insurance?
Well, this perhaps picks up on something I thought of earlier, which is that policyholders can sometimes be just completely surprised or flummoxed for the reasons why an insurer is not responding to the claim, because having taken out a policy for the broad situation which transpires
and paid premiums for many years,
perhaps paid premiums for years, then finding that the insurer resists. So there's often a surprise that the insurance policy doesn't fit the situation, but that's a mixture of perhaps the suitability of the product, but it's also a reflection that not every document, not every policy can perfectly respond to the real world. And the real world situations are sometimes not fitting perfectly into pigeonholes.
Especially unknown events like COVID.
Indeed.
Yeah.
All policyholders should maintain records and try and keep a track of what circumstances are happening. So a couple of years ago, I had a business interruption claim with a big waste processing facility that had large plant and equipment, and one of the pieces of plant failed. The next morning there was ash, there was seemingly heat marks on the big metal equipment, but the CCTV hadn't been working for a few weeks, and so there was no video record of what probably was a fire. But if there was a fire, and ashes and heat marks suggested so, where was it? Why did it occur? And was it an insurable peril, or was it a lack of maintenance and the machinery had got overheated from not being greased? So the record keeping,
that's the evidence ultimately,
and
isn't it?
That's perhaps a stark and perhaps an obvious example, but being able to demonstrate what might otherwise be bleedingly obvious to a policyholder is what's necessary to then bridge the gap and ensure a smooth claims and recovery.
That example reminds me of an insurance case that I had a number of years ago that related to an aircraft that was insured for permitted purposes, and ultimately it was being used for a movie on a movie set, and one would expect that it would have been filmed, but it was a rehearsal. And what had occurred was the insurer ultimately declined indemnity on the basis that the aircraft was being used for an unpermitted purpose, and that an exclusion in the policy prevailed. And the case ran, and it was at the last hour on subpoena that video footage of the rehearsal of the aircraft surfaced. And
demonstrative evidence.
Yes, that's right. And ultimately, so that record keeping, and also record keeping, would you say, Chris, in even prior to inception of the policy? Do you think that intention of the parties and what was ultimately being communicated and agreed on when the policy was being incepted?
Yeah,
is important.
It's very easy for the lawyers after the event to wish for things that could have existed, but good practices that do keep records of communications will always be able to shed light on the events that happen later. How
important do you think it is when there is a dispute many years down the track as to whether or not a policy will cover you for an event, as to what the intentions of the parties were? from the outset?
Well, the interpretation of contracts depends on what is objective rather than either of the parties' own internal intentions. So to that extent, intentions aren't able to be taken into account. It depends on what's documented. What we found in the Princess Theatre Group case was that one of the renewals for the policies had taken place almost at the time that COVID was emerging, and there were initial attempts or publications by the insurer to cater for this new development. And when one of the terms of the policy didn't suit the insurer's interests so well there, they brought a separate argument for rectification to change what was otherwise written. And in that situation, the intentions of the parties become relevant, because the argument is to put aside what was in writing and explore otherwise what was intended. And in that case, it needs to be a common intention. The two parties need to have an agreement about what they really wanted the agreement to be. And in that case, there wasn't common intention, and so the insurer was stuck with what was written in the paper, in the documented policy. But otherwise, the intentions aren't. It's very difficult to bring about.
It's one of the most difficult arguments in the book.
It's the toughest gig in town to bring a rectification case, isn't it, in insurance? It's very difficult.
Perhaps especially for an insurer that promulgates its own policies.
Yes.
What's one legal term you wish people actually understood?
Well, one thing I had thought about in relation to this is that so much of recovery of insurance loss and indemnification for it depends on what has been caused. And causation of itself is a difficult concept. That's the more you scratch it, the more it becomes philosophical, that how are two events actually connected and what does it mean for one thing to be caused by another. But importantly, in insurance policies, the connections between two events, whether one was caused by the other and whether consequential loss further down the line was sufficiently caused by the event or peril that it triggered the whole process, is all affected by the language of the policy, because there are different degrees of connection that are needed in order to satisfy the risk that's been underwritten. So what is caused and what is causation is a difficult concept. And so policies, there is significance in the different connective words that are used in policies, whether something's caused by or results from or arises from or is in relation to or in connection with or follows. And so that you say that because in the Mariner Theatre case we had the word follows, and whether or not that was simply something that happened later in time or had to have some other relationship between the closure and the direction or the advice of the government.
And what that really highlights, isn't it, is that every single word can make a difference.
It can make a difference.
Yeah, and every policy can be so different and unique. And that's why every analysis calls for a case-by-case basis, doesn't it? For the Mariner case, their policy was quite different, as you say, to the other policies that were being tested in other cases.
That's right. So it's not always... It doesn't need to be seen as an agonising inquiry into what do the words mean on the page, but in a practical sense, it's how does the agreement, an objective set of principles, respond to the real world circumstance that no one knew the details of before the policy was written. It's matching the two together, which is always a challenge, and there might be different views about whether or not those policy terms do meet the situation that actually transpired.
Yeah, liability is half the question. Causation and damage is the important part of the equation.
That's where the rubber hits the road, yes.
Yeah.
There's often even a causation issue that we consider sometimes, going back to your point before earlier, Chris, about what other policies may have been available on the market at any given time. And it can sometimes occur that a policyholder will come to us and be concerned about gaps in their insurance cover and be concerned that they weren't they weren't fitted with the right policy, as you say, because the occurrence wasn't known at the time. But then there becomes an analysis as to what other policies were available on the market at that time, and was there even such a policy that would have covered for such an occurrence? And this sort of really hits the head on these causation issues as well.
And in a world of climate change, the reality that an insurance product is just not available is one which is quite timely. So what else is there, and whether there is anything else that might be suitable is sometimes a situation that confronts an insured when the time is most needed.
And just before we finish off, we've got a little bit more time. Experts in insurance cases, how commonly are they used?
Well, it can be very common depending on the issues, of course.
And what sorts of experts would you tend to see being called to give evidence in insurance cases?
Well, if we think of the two sides of the dispute or the claim, one is the trigger for the liability in the first place, and the second might be the quantification of loss. There may well be experts needed in the triggering of liability, be it a engineering problem or a professional liability problem as to the standard of performance that was undertaken. And then on the back half, there'll be issues involved in the quantification or the causation. So there may be steps along the path of what event caused what step before the next step, and that might be an engineering question, for example, in a property damage case. But it may be a financial question, and sometimes that will involve an overall assessment or overall impression of how the business as a whole was operating and what would have happened next. Or it might be a more particular targeted question. So sometimes a loss adjuster is perfectly suited to be able to explain the overall calculation of the before and the after, or what hypothetically might have happened separately. Sometimes the areas of dispute in that overall calculation become more honed or refined, and a more specific question can emerge, in which case it may be that the suitability of the expertise needs to be more targeted, or it transpires that it evolves in that way.
Thank you. Well, I think to close, when we introduced this session, we highlighted that policyholders who have been denied coverage, they're often opposed to a sort of sophisticated litigant, being an insurance company, and they come to us seeking advice as to what they can do to challenge and take the next step. Do you have any parting advice or thoughts for any listeners that may be in this sort of situation?
Well, aside from the broad pragmatism of making sure that the candle's worth the game, that it's worth spending the dispute and the distraction, the time and the cost to pursue, assuming you bridge that aspect, it can be, I suppose, be fortified in knowing that if you've got proper grounds and good advice to justify pursuing the claim, then do so. And the example we've spoken of during today's discussion of the Mariner Group was one where the insurer adopted a stance which treated their claim, the same as all the others which had failed, but their circumstance was different, their policy was different. And so having the resilience or the fortification to pursue what is justified in its own terms rather than being treated like everybody else is something that policyholders should be confident in doing.
Thank you. And that's a wonderful observation, Chris, because often policyholders that we act for and speak to, they say we don't want to be treated as though we're a number. We are, they're often, it's their personal assets or it's their business assets, as you say. They've worked really hard to, pay premiums and build businesses and so forth. And so when that day comes, when a traumatic or crisis event occurs, they want to be dealt with fairly. And so we're very grateful for your helping to create awareness and education on this issue, Chris. And it's been delightful having a chat with you today. Thank you.
Pleasure being here.
Chris.
Thank you both of you.
It's been wonderful having you.